Well, the Presidential Election Petition Tribunal has rejected challenges to Bola Tinubu's narrow victory in February's presidential election. After an almost 13-hour verdict, judges say the petitions by President Tinubu's two primary challenges were without merit. Both Atiku Abubakar of the People's Democratic Party and Peter Obi of the Labour Party had alleged widespread fraud. Well, Mr. Obi has rejected the judgment of the Election Petitions Tribunal, stating that he will not relent in the quest for justice and would appeal the tribunal's ruling. In the meantime, Mr. Atiku of the PDP has also expressed dissatisfaction with the decision of the Presidential Election Petitions Tribunal, stating that the judgment was fundamentally flawed.
Presidential election in our country, and the way it was managed by the electoral umpire, the Independent National Electoral Commission, leaves behind unenviable precedents, which I believe the courts have a duty to redress. Our gains in ensuring transparent elections through the deployment of technology was heavily compromised by INEC in the way it managed the last presidential elections. And I'm afraid that the judgment of the court as rendered by the Presidential Election Petition Tribunal yesterday failed to restore confidence in our dreams of free and fair elections devoid of human manipulations. I refuse to accept the judgment because I believe that it is bereft of substantial justice. However, the disappointment in the verdict of the court can never destroy my confidence in the judiciary. Consequently, I have asked my lawyers to activate my constitutionally guaranteed rights of appeal to the higher court, which in the instance is the Supreme Court of Nigeria. It is my conviction that the electoral process in Nigeria should be devoid of untidy manipulations and that the outcome of every election should be a perfect reflection.
Well, let's bring in my legal panel. Joined live in the studios is a legal practitioner, Liborous Oshoma, who is in our legal studios. And of course, right here in Abuja is our judiciary editor, Toby Soniyi. Good to see you, gentlemen, and thanks for your time. You both witnessed these proceedings that have formed the bulk of conversations in our polity at the moment. Let's start with you, Liborous. The conversation now has moved from some of the arguments. You've heard Atiku Abubakar, but again, first let's start by getting an overview of what your views were on the day. It was a long one, a long haul, almost 12 hours non-stop. So was that expected?
Sulai, except I'm deceiving myself, having participated in election petition in Nigeria since 2003, I know that the burden placed on the petitioner in election petition in Nigeria is a very tall one. And with the time limit, it's a very difficult one for anybody to meet, especially when you are, alleging irregularity in the entire feed. So I also knew that it was going to be a very tall order for them to meet. Specifically also, because I also am aware that when you contest election irregularity, because election is about numbers, when you challenge election irregularities, you should dwell on numbers mainly. Even if you're going to challenge, the other technical areas of qualification and the rest, you do not abandon the issues of numbers. So in the event that the low-hanging fruit that you are challenging fails, then you also should be able to, disprove the figures that you allege were allocated to you or that the figures that you scored. That was what APC failed to do in the Osun Election Petition Tribunal, and that is also what the opposition party at the Presidential Election Petition Tribunal also had failed to do, because the moment election results are announced, the presumption of regularity is in favor of INEC. For time past, opposition parties had argued that that presumption of regularities should, be expunged from our laws. As long as you have presumption of regularity in favor of INEC, and then the man who contested, the onus is now placed on him to disprove the regularity that was presumed. Certainly, it's going to be a very tall order, considering also that you do not have the luxury of time like you had in Anambra, you had in Edo, you had in Ekiti and Osun. Now time has been limited.
Well, Liborous, I'll come back to you. Let's bring in Toby Soniyi, because some of the key concerns, Ebun Adegboruwa, Senior Advocate of Nigeria, has been speaking on some of the key things here. And just as Liborous said, he says he wasn't surprised, and knowing full well that the onus rests on those who are alleging to prove beyond reasonable doubt. And he also spoke about the electoral umpire, which he says must be unbundled and free of some kind of interference. Let's now start talking about some of the key issues now. Away from what has been handed down is the talk of law, judgment, and justice. Let us understand what this means, because there's still some form of dissatisfaction for those who feel that they have been hard done by. Toby.
Yeah. What's the difference between judgment and justice? Well, the first is that judgment is what the court, the judges feel is the verdict of a court of law as delivered by the judge. Well, justice for me is much wider. We have got judgment for Tinubu and All Progressive Congress. They have justice. For Peter Obi, Atiku, and their supporter, what they have is judgment and not justice. So between that, I think first it depends on who you ask. But in general times, whatever the court has done, we will admit that is the judgment, well, is the justice. But in English time, I'm going out of law now. Has justice been done? If you are APC, you say yes. If you are PDP, you say no. But beyond that, I remember during when Justice Walter Nogan was the CJN, declared an end to technical justice, that they will not allow technicality to stop them from doing substantive justice. Well, be that as it may, we say in law that election matters are sui generis, meaning that they are in a class of their own. So some of the things that apply to ordinary cases do not apply there. So when you want justice in electoral matters, you need to strictly follow the rules, follow the procedures, and that has been very challenging. I'll cite an example. The court disqualified 10 of Peter Obi's witnesses. If it had been in normal courts, normal proceedings, those witnesses would have been, their testimony would have been looked into. But because it's electoral matter, it's too generic, they removed them. And when you have 13 witnesses and 10 have been struck out, you have to struggle to succeed in that case. So doing justice to a case would mean that the person who won feels that they've done justice to him. The person who loses feels that justice has not been done. But in between the two, we have a judgment. Thank you.
Well, Liborous, looking at all of this, it takes us back to the grand norm, and the basis of which we're discussing this is about law, basically. But again, some will argue that issues of election petitions, which you're also very conversant with, are not necessarily based on point of law. Take us through some of these arguments, because listening to Toby, he's rightly put it. It depends on which side of the fence you sit in. It could mean justice for you, it could mean injustice for you. It all depends on where you're sat at the moment. So, point of law.
Yeah, Sulai. And that's why some people have argued. There's been this jurisprudential argument between court of justice or court of law. And like Justice, like Lord Denny, Master of the Rolls, once said that what is justice to you might not be justice to the other person. But at the end of the day, is the probability, is the scale of justice balance. That's what the law looks at. And then also, another thing that people do not understand is that consistently the Justice of the Supreme Court, of the Court of Appeal yesterday, cited and quoted Justice Nikki Toby copiously, that the law, the court does not go fishing for evidence in the marketplace. The court makes do with the law, the fact, the evidence supplied before it, and marries it with the law. What is the position of the law? And like we say, the law is what the court says it is. So in this case, starting from what are the requirements of the law? The requirement of the law is that, like my colleague has said, for election petition matters, anybody that is disproving the regularity of that process, the onus is on that person to prove that the process was not regular, which for me is almost like for a presidential matter, considering the 180 days rule, is almost like the camel going through the eye of a needle, considering the fact that you have to prove polling unit by polling unit. That is a tall order. So that is the position of the law. And then also the position of the law is that once INEC announces a result, rightly or wrongly, the law sees it as correct. That is the position of the law. That you cannot take away. So now, the man who conducted the election, the law already says, if you have problems with it, the law already says, you have done everything that you are supposed to do. You have done so well. So it is the duty, the man now sits down in court, folds his hand, and it is you who is a participant in the election, who is saying, no, this process, the procedures were not followed. Who will now need to bring material evidence to show one after the other, bit by bit, pieces by pieces, that these procedures were not followed? I think that is being unfair to a petitioner or a participant in the election. Also, the next thing is, what is the position of the law also is that if that man also, he has 28 days within which to bring a complaint. And if he brings that complaint within 28 days, if there is any mistake in it, he cannot amend it. Also, that's the position of the law. Also, after in filing his petition, he must also file the list of witnesses he needs to rely on. Mind you, some of these witnesses, some are in Zamfara, some are in Benin Kebbi, some are in Anegbete, some are in Eremukogware. So you need to gather them together within that 28 days. And you also need to give a list of all the witnesses and file alongside with your petition. And then also the deposition they are going to adopt in court, that is the position of the law. You need to file all of this within that time. Failure to so do, at the end of the day, the court will say, well, this one was not filed within time, this one was not filed within time, or this one came in the course of the matter, and so. And that's why you also heard the court saying yesterday that the issues of witnesses that were subpoenaed, those witnesses we also have what we call the twin pillars of natural justice. That is the law. You must hear, no man shall be a judge in his own case. Nemo judes in caseswa, or the utterance pattern, you must hear the other side. And that when the other side is not given the privilege of opportunity of having a bite on documents, then also those documents will not be relied on. So all of these put together are they are strictly strictly established that the court must not depart from it. Otherwise, the court will be pandering towards technicality in place of the position of the law. And so, also, it is akin to a criminal law where you say it is better for 99 accused persons to go free than one innocent person to be punished for an offense he did not commit. So when you put all of this together, and at the end of the day, like Toby has said, when these matters are decided on the basis of these laid down laws, the man who did not, win at the end of the day will say justice has not been done. But mind you, I will quickly say this to break it down for the layman to understand. In Oshoma, for example, the PDP got judgment at the Supreme Court. The issues are similar to the issues that were argued yesterday. It was justice for the PDP. It was justice for them, but the APC criticized the judgment and they were not happy. Today, or yesterday, the tables have turned. The same set of facts, IREV and the issues of INEC. The PDP today the shoe is on the other foot. APC got judgment. The PDP that eulogized that Supreme Court judgment now today is criticizing the judgment and say justice had not been done. While APC that said in Oshoma justice was not done, today is saying, yes, this is victory for democracy, this is victory for justice. That is the way the law operates, and that is the way politicians also operate, and the lawyers also operate, in as far as law, justice, and what was the other question? Judgment, concerns, in as far as those, three jurisprudential dictum or statements are concerned.
Then it brings us now to see how much we can remedy the situation so that it doesn't look like that's how lawyers or how the court operates. First, the people came together to say, let's have a body of laws that will guide us. Now, looking at what it said on the day concerning INEC, it would seem as if INEC can cherry pick how the collation can go. It brings us back, this is to you, Toby, before we come back to Liborous. It brings us back to review of our Electoral Act. Are there places or portions, sections that need such expeditious amendment?
Yeah, thank you. I think not just Electoral Act, the Constitution is also very clear. When we do a community reading of both the Constitution and the Electoral Act, it's obvious that INEC has so much power, so wide powers to do several things during an election. That is one of the errors that people tend to not to see. The power that is given to INEC is so wide that it determines how to conduct an election. To a larger extent, I agree with them that INEC can cherry pick how to collate, how to, those who say that they are bound to use electronic transfer, I think they are stretching the provisions too far. I mean, it's very clear. The sections in constitutions and in Electoral Act, they are so wide that they determine the dates, they determine how. And when somebody has the power to determine how, if I say we are going to vote 7 p.m. to 6 a.m. in the morning, they have the power. We have given them, maybe, like you are trying to suggest, it might be time to amend some laws. But between you and I, it's not just about law. All over the world, laws are not perfect. It is the people that matter. There are issues that the mere allegation against someone, he will resign. But it doesn't happen here. No matter how many amendments we do, unless actors are ready to play by the rule and to hold on to some moral obligations, we are never ever going to get it right. We can do 1 million amendment. Once the politicians, the police, the INEC, the voters, as long as we are not ready to make things work, no law can help us to make things work. That's what I have observed so far. Because we thought that, well, several amendments would do. But it turned out that whatever amendment that comes, politicians have a way of undermining it. So the problem for me is not really the law, it is us. And then maybe we have to begin to ask ourselves, how do we begin to do the right thing? Except voters, INEC, officials, security agency, everybody agreed to do the right thing. We are not going to get the result that we so desire. Because with this judgment now, we've seen from politicians, they struggle to win, whether by violence, by crook means, by any means. Once they declare you, for the other person to unseat you, it's so difficult. And this encourages the violence that, let me win first. So we need to know that there is life beyond election. We need to know that we need to live peacefully together. We need to do things that, you know, I mean, we used to cite the example of US until Trump came, which means that as it is in Africa, so it could be in the Western world. Because ordinarily, I remember, was it Al Gore? He didn't, when the court ruled, he didn't bother. He just accepted it. It's not that he did not have other issues that he could have raised. But he said, no, American is bigger than me, so let's do this thing. Let us begin to do right things. We are not, between you and I, we are not doing things rightly, and it is causing a lot of dissatisfaction among the citizenry. So we amend, but will they abide by the amendment? That's a 1 million question.
And it's a question that must be answered, Liborous, because it comes to the argument, some have said, well, the problem that the failure of the people and the institutions, for instance, maybe, or the challenges of such institutions like INEC, are all heaped on the judiciary, to the extent that everyone would think that it's the judiciary that should decide. So as Toby has said, we've seen countries where constitutions are not written, yet they have a fine moment in their succession processes. What should Nigeria do now? Because the president, Bola Tinubu, is 100 days in office, and this election has just been decided, and there's still another journey to go with the Supreme Court. But keep in mind, the man who is the president today didn't put these laws down. So how can a country come together to fix this?
Sula, if you remember, after the election in 1999, by 2002, there was an Electoral Act Amendment 2002 that we used in conducting the election 2003. By 2007, there was an Electoral Act Amendment 2006 that was used in conducting the election in 2007. By 2011, there was an Electoral Act Amendment 2010 that we used in conducting the election for 2011. By 2015, there was an attempt to amend the Electoral Act, even though it was belated, but eventually that didn't sail through. There was also another amendment that Buhari did not assent to because it was part of the election in 2019 until 2022 amendment, that fantastic amendment, and everybody gave it thumbs up. I quite agree that, yes, human being also plays a very crucial role. But like I said, a situation where elections, we always look towards the court in determining election outcome. We believe that the man with the wider power and money bag will believe, okay, let me get there first, and then you go begin to prove irregularities that is usually very difficult to prove. And so, when you have that mistrust, no matter the amendment that you do, people are always going to challenge the process. Except you have, people, you have an umpire that is insulated from, the main government of the day. And then the appointment, mind you, remember, in 2010, there was a debate on who appoints the umpire, how should members of the national commissioners of the umpire be appointed to ensure that they are truly independent. All of that, we debated it, but the moment the election produced a desired outcome, we went to sleep with it. And then also, all of the issues that were raised yesterday, all the issues that were raised yesterday by the Court of Appeal had been raised previously by the Supreme Court. So there's basically nothing new under the sun in as far as election is concerned. But the only recurring thing that I have consistently mentioned is the fact that when INEC declares the results, INEC would want to, the tendency to want to swim and sink with the results so declared is very high, considering the fact also that the law presumes that whatever you have done is regular. And so it is the man who is disputing that the burden of proving irregularity is on. So if you, for as long as that provision remains, and the umpire, because that provision is there because there's a presumption that the umpire will truly be unbiased. That was why the drafters of the law crafted it that way, so that the umpire will be biased. But a situation where the umpire is appointed by the government of the day, members of the resident electoral commissioners of the umpire are also nominated and screened by members of the National Assembly, partisan in some cases, even though the law says that they shall not be partisan. But we see cases where some persons who are clearly partisans are nominated. Once you have such an umpire, and then yet you presume that the law of presumption is in their, the law of regularity is in their favor, you are going to have consistently where participants, actors will challenge the process, even though they know that at the end of the day, you know, it is going to go in a certain way. Because it also gives their supporters hope. Because if you refuse to challenge the process, your supporters also might think that you have been compromised. And so that is why you are not challenging a process they feel that it is glaring. But not forgetting the fact that the law also makes it a very tall order for you to surmount. So all of these, I think, yes, we need to some extent, consistently continue to tinker with the law to enhance transparency. Take the issue of IREV, for example. The beavers in 2015, the Supreme Court said because the beavers was not a part of the, our laws. And so in reckoning with overvoting, you cannot be talking about the beavers. You have to have records to, the electoral register. But the law was amended to accommodate the accreditation using an electronic device to accredit. So that accommodated the beavers. And now when you discuss overvoting, it must be unlike before. It must be the number of accredited voters by the beavers as against placed side by side with the number of actual voters, unlike before, when it was just number of registered voters as against number of accredited actual voters. Quickly. But today, the IREV, for the IREV, the law has simply said INEC shall transmit in a manner they so deem fit. So once you have done that, you have left that at the discretion of INEC. So if INEC says we are conducting election by 9 p.m. and they now say 9 a.m. and they now say for logistical reasons we are not able to conduct election by 9 a.m. we'll shift it to 2. And you say no, because you have told us that it must be 9, and failure to conduct by 9 is fatal to the election. And the court says, well, since it is their discretion on when to conduct election, you cannot hold them to it. So these are some of the issues that also we need to look at in discussing, the way forward also. Should we leave this discretionary or should we make it part of our laws? Because the Supreme Court also was consistent in the case of Oshu on the issue of IREF.
Just let me quickly put this so that we can wrap up, and it has to do with reforms. We saw a lot of lawyers on the day, journalists all sleeping. It was a tedious moment. And is that the way it should go, Toby? Must it be that tedious?
Well, that is not the way, to be specific. And I think it also showed to us that even the judiciary needs help. I mean, that is obvious, I have written about it severally. The judiciary needs to be reformed. We cannot continue to do this long handwriting. is killing our judges. Many are dying before they reach retirement age. But the problem is the judges refuse to change. All over the world, stenographers take notes. You just take your own notes, you look at the important thing. You don't need to write yourself to death. They don't need to read themselves to death. They don't know how much damage they have done to their heads that yesterday. So read the judgment for 13 hours. I'm sure they probably should be seeing their doctor today. It's not proper. It's not the way it's done in other places. And technology is there to help. I understand they want to be transparent, but you can still be transparent by adopting modern technology. So our judges should not, they should embrace technology. They should reform the process of note-taking. We don't need to still keeping writing. That's why the process is very slow. If a lawyer coughs, they write it down. If he sneezes, they write it down. Then something that you should do for 5 minutes, you take 2 hours to do it. Then 6 years, a case is still pending before the Supreme Court, and they don't seem to be bothered. We can blame lawyers, we can blame others, but the judiciary too must accept responsibility. And I have said it before, if they don't reform themselves, the National Assembly will pass a law one day and say all note-taking must be by it should be done electronically. That is when they will start to struggle to learn how to use iPad and what have you.
On the same issue, let's hear from you, Liborous. Sleeping lawyers, journalists, and everyone fatigued on the day. Judicial reform?
Yeah, law practice has since become very conservative, and I will not talk about that without also talking about the issue of all eyes on the judiciary, all eyes on the judiciary, and that also would put pressure on the judges wanting to be very transparent. You know, judgment that ordinarily you deliver just go straight to the holding of the judgment and say, well, we have read through all the bodies of the argument profile, and then this is our holding, this is our ruling, or this is our judgment. And then the other judges would either agree or disagree. And then lawyers and participants, you can get copies of the judgment and read through, which is what they usually do, even, you know, at the Court of Appeal in other matters. But because of the sensitivity of this case, you will discover that what judges do in court in Nigeria, you know, came to light yesterday. There have been attempts at reforming the judiciary, at note-taking with microphones and stenographers in court, but that had not been strictly enforced. Lagos State started it under Professor Yomi Oshoma as Attorney General, and yes, he's still there, but that idea of taking notes in long hands is still very, very prevalent in our court. And I think also coupled with our attitude at embracing technology, and our attitude of also, in some cases you hear lawyers say, "My Lord, I wish to be recorded." You know, so as lawyers, our attitude of, holding tenaciously to our pasts, including the wig and gown issues. So I think we need to proceed beyond this, because really sitting down to read a judgment, no matter how much, pressure, sitting down to read an entire judgment, even though here we don't read, I can tell you that a lot of lawyers probably wouldn't have bothered listening or reading that judgment if it wasn't read live, including people who, want to know what lawyers do, or who have turned to modern day lawyers, wouldn't have even bothered reading it. They just take snippets of it and begin to discuss and argue. But in trying to be transparent, also we can, use modernity, use technology to be transparent. I'm here in Lagos or in Abuja, and we are talking. And so you find out that I think these days,
I'm sorry to cut you there, Liborous, because we're really out of time. And again, the good thing about technology, yes, truly, you're in Lagos. I'd like to say many thanks for being such a nice company, Liborous Oshoma, a constitutional lawyer, and of course, Toby Soniyi, many thanks for being such a nice company.